Hi, everybody. Welcome to Trial Alchemy. And I have as my guest today retired Judge Jeffrey Barton. Let me tell you a little bit about Judge Barton. He started practicing law in 1981 in San Diego, and he was an accomplished civil trial lawyer for many years. He was a partner at Lewis D'Amato, Brisbane, Biscard, and he joined Aboda in 1995, and then Judge Barton was appointed to the Superior Court bench in 2001. But he served throughout his time on the career bench from 2001 to 2021. He was 12 years in the Civil Independent Calendar Department, but he also had many other assignments, including family, criminal, open trial department in all kinds of cases. He was the assistant presiding judge for 4 years, from 2014 and 2015. Then he was assistant presiding judge for 2 years, and he was presiding judge of the San Diego Superior Court for 2 years in 2016 and 2017. And he served in many other capacities during his time on the court. So without any further ado, Judge, let me just welcome you to Trial Alchemy. Thank you for joining us today.
Well, thank you, Monty. It's a pleasure to be here, and thanks for asking me.
Well, I appreciate having the judicial perspective, and I think it's going to be a useful and valuable discussion that we'll have. Now, most of the discussions on Trial Alchemy are talking about the trial of cases, and we're going to get there. But I want to start a little bit before the trial, considering your experience. So let's start first with an area that all lawyers, even if they haven't tried many cases or any, start with, and that's law in motion. And do you have any, from your years of serving on the bench and being an independent calendar judge in the Superior Court, do you have any tips or suggestions that you would make that would help lawyers do the best they can do in the law in motion arena?
Yeah, I have several ideas based on what I did every Friday for 12 years. I think one of the most important things is first making the decision whether you need to go to law in motion, and making sure that what you're doing moves the case forward. There are a lot of times when law in motion seems to be an end in and of itself. So, for example, on discovery matters, oftentimes the only meeting and conferring that's occurred before the filing of the motion is sending emails back and forth, basically threatening the other side with everything that they're doing wrong, as opposed to truly meeting and truly conferring, either in person or by telephone, and with the people involved in the case who have the power to make decisions. So I think screening to begin with is very important. Another aspect to that is demurs. And I know you and I were trained similarly in regard to demurs, and it can be a useful weapon, but you need to use it under circumstances where you can actually accomplish something and have a true shot at knocking out a significant cause of action that will affect the complexion of the case. Saw many times what I call the defense quest for the perfect complaint, where you'd have a super specialist defense lawyer, plaintiff's lawyer who perhaps wasn't as fluent in the current state of the case law. The defense lawyer then would point out all the defects in the complaint, point out all the cases that supported those defects, and educate the plaintiff's lawyer to the current state of the law. When you're actually filing your motion, it's amazing how many motions start with like a procedural history of the case or sort of boilerplate citations about the power of the court to grant a motion for summary judgment, for example, which is all stuff we already know. I mean, you might have to throw it in there, but you need to start your motion with something that attracts the judge's attention, and to indicate in the first 2 paragraphs, maybe 3 paragraphs, what it is you're seeking and why you're entitled to it, and try to do that in an interesting way, rather than starting with the complaint was filed on July 1st, the answer was filed on, August 15th. And many motions start that way. And as someone who's reading 18 motions for every Friday, it's just not the best way to get your judge's attention.
Well, let's go over these a little bit more. I think they're all great suggestions. So let's say first about meeting and conferring. What I've noticed when I've been involved in dealing with discovery issues, typically in my situation as a referee, so you did it every week as a trial judge, but if you only send a text or if you only send an email, what I've seen is people don't tend to really meet and confer, and they don't tend to communicate. They just kind of harden their positions. Do you think it's better to talk on the phone or talk in person? I think that's at least in person if you can, but if you can't, at least on the phone, and try to really communicate. What do you suggest about that?
Absolutely. I mean, a lot of times the emails that go back and forth are really just sort of rough drafts of the motion they're going to file.
Yep.
And there's really no meeting and no conferring that's going on. It's stating positions and threatening sanctions. And that usually gets the other side's back up. And I think proof of the fact that actually meeting and actually conferring, and that means at a minimum on the phone, hopefully next would be by Zoom and best in person,
Yeah.
is the fact that so many issues resolve out in the hallway while waiting for the motion to be heard, or more importantly, or more realistically, on ex partes when counsel are waiting to get called up to get their order shortening time to get their motion heard. And because that's the first time that they've actually sat down eye to eye and had to compromise, and in fact did, and realized that their opponent's, a nice person and not someone who's just threatening to sanction them $50,000.
Well, you and I did have similar training. We were lucky to get trained by great lawyers at the McGinnis Fitzgerald firm in the
Yes.
early 80s. But in terms of being an effective trial lawyer, whether you're in the trial court trying a case in front of a jury, or you're in front of a judge or working your case through, it's really important to be thinking strategically about that case from the very beginning. What is the goal? What's the best result you can get for your client? How do you get there? And if you're thinking strategically, you get to one of the points you just mentioned at the beginning is, well, do you really need to file a motion on a discovery issue? Is there some way you can resolve things and get something that you really need, but not fight over stuff that's not going to be that important? So, I mean, there's a lot of motions that are probably filed as discovery motions. I'll bet you saw a lot of them that maybe you don't even need to file.
True. And I think the root of that is something that I'm sure you see as a referee, which is over-inclusive discovery requests that just
Right.
lead to problems. And it's almost as if lawyers are sometimes reacting in a step-by-step process. In other words, okay, it's discovery. I've got to get every single document that the other side has, for 10 years preceding whatever is relevant in the case, and not sitting back and thinking about trial and what it is they're going to use and what they actually need, and perhaps tailoring their discovery accordingly. I was trained by a lawyer who had 3 interrogatories that went out on a case, and then later when I was farther along in my career, I grew that to 7. And really, discovery is useful to identify documents, people, and contentions.
Yep.
And anything past that is really not that effective.
Yeah, like in discovery, I think interrogatories are most useful to try to find out who the witnesses are and what the documents might be. Document requests are good for getting the documents,
Right.
and then take the depots and find out what the witnesses say and get their testimony committed. And now you're prepared for trial.
Right.
But you don't have to fight over, you know, hundreds of interrogatories. Get the documents and then take depots.
No, and I mean, oftentimes what you'll see is interrogatories, for example, that go through the complaint line by line and say, please state each witness, each fact, each document that supports your contention in paragraph 26, lines 2 and 3 of the complaint. Then the next
Right.
one is, on and on and on. And it's relatively easy, I guess, to crank those out. It's very difficult to respond to them. And at the end of the day, it's not an effective use of the lawyer's or the client's resources. When instead you can just ask more broad-based questions, if the case revolves around an event on a certain date, ask the identity of all the witnesses that you know of that were present or know about this incident on that date.
Right. And going back to being strategic, let's then go to the demurrer example you gave. The problem with the demurrer is most demurrers are going to be either sustained with leave to amend, or if they're overruled, um, if they're sustained with leave to amend, you've made a point, but all you've done is educated your opponent, as you said.
Yeah.
But have you really helped your client? Have you helped your client get a good result? You've kind of spent a lot of money, a lot of time, and educating your opponent isn't necessarily helping your client. So there are some demurs that may be good to make. And so in my experience, for example, let's say you see a statute of limitations issue that you think could be decided on demur, shoot,
Yep.
that's a way you might end the case. If you're on the defense side, then that's a valid demur to make. But if it's likely to be sustained with leave to amend, I think you got to think about that carefully.
I think that's true. And there are some that you have to bring. For example, punitive damages or issues of claims that may fall outside your client's insurance coverage. And
Yep.
if it's not adequately stated, you probably have a duty to challenge it, unless strategically you don't want to, because you'd rather not educate your opponent. And then you need to CYA with your client about why you're not doing it, I would imagine.
Yeah, I think that makes a lot of sense. And then going to the writing of a motion, and this could be any kind of a motion in front of the court. Um, I think your suggestion is great. One of the things I started doing years ago, and I probably got this idea from somebody, I think it was a judge, is make your first paragraph the issues to be decided.
Right.
And just say, well, here's what you have to decide, and now start to explain why you think you're entitled to it. And that's what the judge needs to know. He doesn't need a novel about what's going on in the case so far. They want to find out, what do I have to do?
No, and it's kind of similar to a trial. If you can't explain what you want and why you're entitled to that relief under the law or the facts in a few paragraphs, then you got a problem. So
Boy, is
it's
that
always a good
true.
idea to be very clear about that.
Well,
In motions in limine, for example, you'll get, and we'll probably talk about that later, but
yeah,
probably get sometimes dozens of them filed, and each one starts with the same 6 pages of boilerplate. So you're sitting there on the weekend before your trial start, and every single motion you turn to has the same 6 pages of boilerplate before you get to what they actually are talking about. And
yeah,
can tell you
that's
from personal experience, it's not a good tactical way to get a ruling in your favor.
well, this is a good segue for us to start talking about the trial part of a case. And let's start off with this from your experience on the bench. I mean, you were on the court for 20 years and tried a lot of cases, presided over a lot of trials. But can you think of, in the civil IC department, a case that you thought was, you probably saw a lot of these, but what's an example of an interesting trial you presided over that you thought was interesting?
I had a bunch of them. I think one that was interesting both because of the facts and because of the outcome was a case where this young married couple had a miscarriage at about almost 6 months of gestation.
Mm.
And they were obviously very upset about that.
Mm.
And they wanted to have a funeral with a casket and the whole deal. And so they arranged with a mortuary to do that. Mom went out and bought doll clothes that would fit the 5 to 6 month old baby, and brought it to the funeral home. They then came to the ceremony, I mean the cemetery on the given day, and there's going to be a graveside service, and the priest apparently miscalendared it, and they got in touch with him, and he was going to be a couple hours late. So mom said, well, I'd like to see and hold my baby. And the funeral people said, no, 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 you can't do that. And you can't do that here at graveside, and on and on. And she said, well, then let's take the casket back up to the funeral home and I'll do it there. We've got, at least 2 hours. So they take the casket back up to the funeral home and keep the parents waiting like 45, 50 minutes, and finally come out, excuse me, and tell them that their baby's not there. And that
Oh my goodness.
it turned out what had happened was the driver, when he went to the hospital to pick up the remains, there were apparently 2 buckets with the family name on it, and he picked up the bucket that had the placenta in it,
Oh no.
and he did not get the right bucket, and brought that down to the funeral home. And when they opened it and saw it, they just scotch taped the dress to the top of the bucket and put that in the casket.
Oh my goodness.
And so it was somewhat of an aggravated circumstance that caused a great deal of emotional distress. Later, at a different funeral home, a different driver went and actually got the baby, and they actually were able to have the funeral. But so the jury deliberated, and obviously the gravamen of the case was emotional distress.
Right.
Came back with a verdict of, I forget exactly, but over $700,000 for the plaintiffs.
Mm.
And then defense counsel did juror interviews with a private investigator after the trial, and got a number of juror declarations that one of the jurors, who was a social worker or mental health care professional in some fashion, I can't remember what, violated the admonitions and copied pages of the DSM-4, the Diagnostic and Statistical Manual of Mental Diseases, and brought photocopies of the DSM into the jury room to convince the jurors that
Mm.
the emotional distress was real, and here's the correct diagnosis for it, and the experts were wrong when they said this, and the defense expert was full of it, on and on and on.
Wow.
And so that was unrebutted, and I had to end up granting a motion for new trial. And the case then settled thereafter for an amount I don't know about. But that was an interesting case because, one, the facts, and two, clear jury misconduct, which is really rare, especially in light of all the admonitions we give to prevent that.
Yeah.
So that
Wow.
one sticks out.
Yeah, that must have been an interesting case. So let me ask you a question I like to ask my guests, and I want to ask it differently from you as a judge, but let's preface it this way. When you were a trial lawyer and you tried cases for many years, um, 20, 20 years basically, when you were a trial lawyer, what did you think was the most important part of a jury trial? And then when you were sitting there as a trial judge presiding over trials, did that view change? And what do you think, if it changed, as a trial judge, is the most important part of a jury trial?
Well, I think the pat answer is jury selection, and not so much voir dire, but the makeup of your panel. But in reality, I think the most powerful part of trial is cross-examination.
Hmm.
And I think not only the lawyer's cross-examination of the opponent's witnesses and experts, but equally of importance, how your client and your experts hold up when cross-examined by opposing counsel. And there were, in my experience as a trial lawyer, um, there were many times I think where my cases were won by how my clients did when they were cross-examined.
Oh, I bet. You were often defending medical malpractice cases,
Right.
and if your clients did well on the stand, I'm sure that really was significant for getting a good verdict for them.
Correct. Correct.
Okay. Well, um, I think I agree with you. Cross is a very important part of the trial. And in terms of types of cross that you've probably seen all different types. I mean, the most standard cross I would call the closed cross, the way we're taught in law school. And probably most lawyers use this and used it in your courtroom where you're controlling the witness, answer a question, they're answering yes or no. You're not giving them much rope. And then you're really trying to go down and make your points. But there's other types of cross that I would call in San Diego the Milt Silverman approach or the Jerry Spence approach, where it's more of a kind of a crazy, wild, open cross, and the examiner almost doesn't care what the answer is. Did you see different styles of cross, and did you find them to be effective? And what were your observations about that?
I saw a lot of very good cross-examination, and I saw a lot of really poor cross-examination.
Hmm.
And I think the hallmark of poor cross-examination is not having something to hit the witness with when they say something different than you expect with your question.
Yep.
And it was surprising how often that would happen. Or
Hmm.
someone would ask an open-ended question and then start trying to object. Um, and as a judge, you'd sit there and go, well, I think, you think to yourself, you don't verbalize it, but well, your question ended with a why,
Yeah, you
so
asked the question.
yeah. So it's surprising how often lawyers, and I think it relates to the fact that there aren't a lot of cases being tried now.
Right.
And the cross-exam style isn't the questioning style that you use in a deposition when you're trying to get information. And so lawyers nowadays don't have a whole lot of practice at that kind of law school cross-examination.
Hmm.
I think the best cross-examinations I saw were where lawyers started out with a very tight cross-examination and would hit the witness with something that impeached them or redirected them and showed the falsity or the exaggeration or the sort of advocacy in their answer with something, and then could loosen up later once they had the witness sort of under control and intimidated. I remember as a young lawyer trying a case with Doug Reynolds, and he did that. He started cross-examining this guy, and then just basically the guy would say yes to whatever he said. And when he reaches in his briefcase and pulls something out and puts it on his desk and looks up and asks, like the $1 million question, and the guy answers yes. And later I asked Doug what that was, and he goes, "Oh, it was just a notepad, you know."
Yeah.
And so once you've got the witness on the ropes, then you can score more and more points.
Well,
And
you
from
go ahead.
impeachment, I was going to say the most effective I saw was very tight use of videotape deposition with the transcript running in the bottom of the frame, with very fast and very fluent use of trial director or whatever their software was. So there's almost no hesitation between the end of the question and the time the video plays.
Yeah,
And
I don't think
that was
you
best.
worry. I don't think you worry hesitation. I use Trial Director, and I found that having video clips was the best way to impeach, the best way to use that in cross. It's fast. The jury sees the witness. They see the testimony underneath it because I like to get the transcript as well. And
Right.
they only listen to the part that you want them to hear.
Right.
You know, like
And
in the
then
old days, when you had to put a page of a transcript up on an Elmo or something, they could read everything on that page. But this way, they only see and hear what what happened. So I think that's a very effective tool. Sounds like you saw that was very effective as well.
yeah, I think in the ineffective way to impeach with a deposition is to not lodge it per the court's directive at the beginning of the trial.
Right.
Um, and then it runs the gamut from they go, I'd like to read from, page this to page that. Objection, Your Honor, that's irrelevant. And I go, well, could I have a copy of the transcript? And then they fumble, or I even had cases where the person asking the question didn't have the transcript
Oh my
and was
goodness.
then asking, it was just on their computer and was asking the opposing counsel if they could borrow theirs, and that was entertaining. And by the time a transcript got up to me and I was able to look at it and rule, I'm not sure the jury had any idea what the question was.
Oh no, not by then. Well, one
Right.
of the points that I think you've made, and also you've probably seen, is would you agree with me that if you're going to try to construct your cross, you want to start with something that's a big thing, big point you're trying to make with that witness, and you certainly want to end strong as well. And it's really helpful to start strong and end strong. Have you found that to be useful in cross?
Yeah. And also to have the ammunition to control that witness on those
Right.
big points so that
Yeah,
you
you
can
got to have
impeach them right out of the bat,
you
out of the
gotta,
box.
yeah, you gotta have it right out of the block. And I think the other point you made with your Doug Reynolds, and what a great trial lawyer Doug Reynolds was. But if you have a witness and you're crossing them, I found that to be true too, that if you hit them with a question, then you hit them with impeachment, hit them with a question, hit them with an impeachment, after a little while, they just
Yeah.
start saying whatever you want them to say, even if you can't control them as much.
Right. Yeah. I tried a bench trial once in front of uh, Kevin Miller or Keith
Midlam?
Midlam. And I was impeaching this witness, the plaintiff, just over and over. And I asked the question, and he goes, "Is that just another direct quote from the deposition?" And I go, "Yes, Your Honor." Because I would take the quote and then add it, "Isn't that true?" to the end of it. So,
So in terms of cross-examination, have you seen lawyers use a more open approach that's also been effective, or is it most commonly been effective with the more closed controlling approach?
I think the best ones have been ones who mix the two and control the witness first with the more closed approach,
Mm-hmm.
so that unless coming into the courtroom, they'd already softened the witness up by depo or by who knows what. But um, yeah, a mix of the two, so that the witness never got turned loose, so to speak, to get their side of the case in unrebutted.
Okay. And just to kind of finish this little area, um, is the importance of cross-examination in trial something that you believed as a trial lawyer, or did you come to believe it more as a trial judge?
Um, I would say that was something that my opinion did not change on.
Okay.
I always thought it was really important. Um, and it when I was a trial judge, I thought the same thing. I mean, I saw cases won and lost, in my opinion, on cross-exam.
Yeah, I think as a trial lawyer, and when you're sitting on the bench as a trial judge, you're now not being an advocate, but as a trial lawyer, and I'm sure you had this experience, when your client or one of your witnesses, expert or others, is being cross-examined, those could be very tough moments for the trial lawyer because you got to sit there with a poker face, and
Yep,
the other side maybe just destroying them. And you
yep,
don't have anything you could do. You could object if it's appropriate, but you just got to
right.
sit there and take it.
You do, and you can't show it because you don't know for sure if the jury is comprehending the full magnitude of what's going on.
Yeah, you have no idea, and you don't want to give up the ship that you think you're getting killed and show anything.
Yeah, and your client also, if your expert's up there and your client is thrashing around and writing notes and giving them to you. I had one guy who kept reacting so much at counsel table that I had him sit behind me and told him, stop, don't do this. You're just scoring points for the other side. And he wrote a post-it note, stuck it on his shoe, and tapped me in the butt with it so that I could, get the post-it note from behind him. And all it said was, "She's wrong," and I'm like, "Oh, that is very helpful. Thank you."
I had I had a trial talking about a poker face. I had a trial once years ago. We settled in the middle of trial with a friend and a colleague you knew at the McGinnis firm, Rick Barton, and I was a plaintiff's lawyer in this med mal case. He was a defense lawyer, and we settled it before it got to the verdict. And the judge brought us in afterwards because he got feedback from the jurors. And one of the jurors said of Rick Barton, he said, uh, they were surprised by his showing his obvious disdain for the plaintiff's counsel. So Rick was apparently reacting and not keeping a poker face there at that time, but that was fun. We laughed about that.
Yeah, and probably inaccurate too, because I don't
Yeah.
think he had bad feelings about you at all.
Oh no, he didn't.
Yeah,
We were both doing our job. So
yep.
now let's go. We've talked about the important part of the trial, most important. Let's talk a little bit about, I think you've tried some cases before you retired when we were kind of coming out of the pandemic, and you had some juries trying cases. From your perspective on the trial bench, did you notice any differences in the ways jury were reacting and making decisions when we were coming out of the pandemic compared to what they were doing before?
Not significantly. I think the biggest difference was particularly because I left in um, April of 2021 in the midst of the pandemic,
Right.
and we were just starting to impanel jurors, and we had plexiglass screens up, and so it was much harder to get a jury, and it was hard to keep a jury because you would sometimes have someone test positive. And so it was a difficult time period, but I would say that people were quite brave during that time period, and I didn't have a lot of people, trying to get off or shirking jury duty. Maybe that occurred by them not reporting at all to the courthouse. But for those that did report, I didn't see a great deal of difference.
Oh, that's great. Well, let's talk about this in terms of when you're starting a trial before the jury gets sent down to you. One of the first things you'll do as a trial judge is deal with your motions in limine, and you mentioned that a little bit earlier.
Yeah.
But do you have any tips on what lawyers should be trying to do with their motions in limine? I mean, I think one of the things I've heard from trial judges over the years in just ruling on motions is so often the lawyers are trying to ask them to prejudge things. They haven't heard the evidence, and what are the kinds of, what tips would you give to lawyers to say, hey, these are ways to try to be most effective in dealing with these motions in limine?
Uh, First, read Kelly versus New West Savings and Amtower versus Photon, or Photon versus Amtower. the two sort of seminal cases on what you can really do with motions in limine.
Yep.
And the second is to use your motions in limine judiciously on real issues that you have a realistic chance of keeping something out of evidence.
Right.
And don't blunt your pick by filing what I used to call it hurts motions, which is, filing a motion for every bit of evidence in the case that you think hurts your case or your client. And obviously, don't put 6 pages of boilerplate in every one of your motions that is identical. I mean, that happened almost on every case I tried as a judge.
Now, I would think, go ahead. Sorry.
So I was just going to say you need to pick your battles there and
Right.
really bring legitimate issues to the court, and then you've got a better chance of the court, seriously considering what you're doing.
Now, a lot of times, a lot of lawyers will file just so many of these motions in limine. And from your perspective as a trial judge, let's say if one of the trial lawyers is more thoughtful about this, and if they say, okay, I'm only going to file 3 motions on things that I think I really have a good shot at, I would think from the judge's perspective, they're going to have a better shot at getting a good result than if they filed 10 motions. And you've kind of diluted your opportunity to get a good result on the strong ones if you throw a bunch of weak ones in.
Yeah, and it's more usually 30, 40. I've seen as many as
Yeah,
136,
it's so many.
Versus 5, 6, 7 on the other side.
Yeah.
And you clearly do blunt your pick by filing that many. I don't think filing a few guarantees that you're going to have winners, but I think I can tell you emotionally when you're sitting in your backyard on a Sunday reading these things before you start a trial and you're dealing with 50 motions all with the same boilerplate, where you got to flip through 7 pages to figure out what it's about. And the other side, when you finally get to, if it's the defense, for example, you get there and there's only 5 of them, you kind of go, oh gosh, thank goodness, and so it's a good idea. Let's just put it that way.
Well, there's sometimes issues that might be, let's say, evidentiary issues that might come up in trial during the trial. And at least in my experience, I think others have had similar experience. It's maybe not an issue that you think you should bring up in a motion limine, but I think you should be prepared in case the issue comes up, the judge has to decide it. And sometimes I've thought, well, maybe I don't know if the other side's seen the issue and spotted it. So if that kind of issue comes up during the trial, if the lawyers thought ahead of it, saw the issue and written a little short pocket brief, how is that? What's the reaction of the judge about that? I think it's a helpful thing. And what's it been in your experience when you've seen those, when the issue comes up?
I think if it's something you don't want to bring up in your trial brief, because you don't know how alert the other side is to it, I think those pocket briefs or in trial briefs are very helpful as long as they are brief and to the point. You hand a judge who's in trial a 40-page brief, and it's not as effective if it's under 10 pages. I think because of due process, the way I handled that is told the lawyers at the beginning of the case before we started that if something's going to come up like that, that's going to require a pocket brief or extensive argument, you need to let me know before we turn the jury loose at the end of the day. So I can tell the jury to come in at 9:30 or 10 or whatever. And I say, if you do that, then I'm going to give you an hour to talk about it. And so if someone gives me a pocket brief and tells me that at 4:30, I tell the other side to get their brief there, get there, before 9 and let me have it. I'll read them both after I finish the ex partes. And then will have, time to do the argument. The other way of doing it is to hand the judge a 40-page brief that's really like your motion for new trial, dressed up as a trial brief at 9 o'clock in the morning with 16 jurors sitting out in the hallway, and the other side's never seen this before,
Right.
and expecting me to break for an hour and read your brief and then put up with the argument from the other side that, wait a minute, we've never seen this before, we need our chance to brief it, and on and on. And I would tell the lawyers, if that happens, and it's an issue that's key for a witness that day, you're going to get 10 minutes to argue it, and then we're going to bring the jury in. Because I took very seriously the judge's role as a trial monitor, and there's a bunch of case law on that, to ensure that it continues to move expeditiously and that the jury is not inconvenienced. And it was always kind of a mystery to me when that would happen, that the lawyers would kind of be immune to considering what effect this might have on their jury, and whether a frustrated jury was really in their interest. Because the biggest complaint we got from jurors was downtime, not starting on time, sitting in the hallway,
Right.
taking breaks. I mean, they want to get in there, do their 9 to 4:30 and get this thing resolved. They don't want to sit out in the hallway for hours and burn more time away from work.
No, and I think that's that the lawyers really need to be considerate of that juror's attitude, because they're really hurting themselves if they aren't. And
Yeah.
if they're forcing a waste of time, they're not going to make the trial judge happy or the jury happy.
Right.
Well,
And usually during the
yeah.
trial, even though you won't say anything, sometimes the jury can figure out by what's going on in the courtroom which side it is that's causing the delay.
Oh, yeah. And one of the issues in the trial that I have found to be the most important, and I'd love your thoughts on it, but it's the issue of credibility, and that's credibility of lawyers, credibility of clients, credibility of witnesses. But the lawyers have to have some credibility, and if the jury gets a sense, like you say, that, oh, I think that side's the one causing all this delay, that's going to hurt their credibility. Has that been your experience?
Yes. Yeah, I think credibility of the attorneys is obviously secondary to the witness.
Right.
But if you don't have it, it's a major problem for both you and your client. And the lawyers who are efficient and move the case forward when they get up, and things they've said in opening statement are coming true before the jury's eyes.
Yeah.
That all inures to the benefit of the lawyer, and in particular the lawyer's client. And those who are saying things that are proven false, and that can happen with the first witness. That's a problem for that attorney.
Big problem. So one of the things that developed during your career as a judge, it wasn't going on in 2001, but it developed recent years as a mini opening. What was your reaction to that, and what did you feel about it?
I was an early adopter. I really liked mini openings. I think they engaged the attention of the jury panel much more than me reading a sanitized statement of the case that was usually pretty boring. And I think you had less people wanting to get off. And second, the jurors had a lot more information about the case than they were going to get from me and the statement of the case that I would read. And I would tell the lawyers, one, you can't argue, and two, you get so many minutes.
Right.
And I will sustain my own objection if you violate either of those. And so you need to be careful and follow this admonition, because if you don't, your very first experience before the jury is going to be getting shut down by the judge.
Yeah.
And so that was always effective in reining it in, because lawyers, they'd have a very hard time with a 4-minute description or a 5-minute description of what the case is about. But I never had a significant problem with it. And you could just tell in voir dire that the jury knew so much more. And so you got better juries as a result.
Well, when you were sitting as a trial judge, and this is certainly an art form, I mean, you as a trial judge, you want to make sure that, a jury who can do their job and be fair and impartial is selected. And you don't want the lawyers arguing their cases and try to precondition the jurors or anything like that. But how did you kind of navigate your way to giving the lawyers sufficient time and trying to let people learn enough to figure out whether any of these jurors would have a problem being able to hear that particular case?
Yeah, I mean, first I would look at the case and hear from counsel what the issues are in the case, and use that as a gauge to have sort of my own internal guesstimate as to how long voir dire should take. I did not have, ironclad rules like you got to do a 35 pack in 30 minutes or something like that.
Right.
And so then I would discuss with the lawyers, how much time do you think you need for voir dire? And that would in part be based on whether we were doing an 18 pack, a 24 pack, a 35 pack, whatever it was. And I would tell the lawyers that if they had a difficult jury, to look over at me when time was up. And I would say, why don't you go ahead for 5 more minutes? On the other hand, if the lawyer was using the time and wasn't really accomplishing a whole bunch, I would say something like, counsel, you got a couple of minutes left, and they'll go, well, judge, can I go 5 more? And you go, sure, and handle it that way. I really never had, it was surprising. I always had lawyers asking for a lot of voir dire time. We would then get it down a bit, and often they wouldn't end up using all the time they asked for. I think doing voir dire is maybe one of the hardest parts of the trial to do well.
It is, yeah. And you've seen a lot of different approaches to people and how they do that.
Right.
So in terms of, let's say you picked your jury, you've got your people on the jury, you're starting the case. What are some of the best approaches you've seen lawyers making, giving their opening statements for either side?
Okay. I think you need to be cognizant as an attorney of who your audience is. And oftentimes, particularly nowadays, where lawyers aren't usually trying 6, 7, 8 cases a year,
Right.
You need to be careful that you're not trying a case as though your audience was a bunch of lawyers. And I saw that a number of times. And you need to be aware of the fact of who your audience is and try the case with that in mind. I had this was just internal. I never told counsel, but I had what I called my own 40-minute rule. And if you're going to go past 40 minutes, in many cases you had to, I don't begrudge that, but 40 minutes is the point in time, in my view, from watching jurors. And as a judge, you can watch them with no pressure on you, where you've got to be doing something pretty interesting to keep them going.
Yeah.
So be cognizant of their time. Be straightforward in your presentation. Add visual aids to it, i.e., evidence is coming in. And I think that is, and finally be accurate and prove everything that you say.
Yeah.
Those are the best guidelines. The way not to do it is to talk about every piece of evidence, not key into the key strategy of your case and the points that you need to win. and bore the heck out of the jury.
Well, you know, one of the things that I like your thought on is that what I ended up developing over the years, you got to be yourself when you're a trial lawyer. You can't try to do it the way somebody else does it. But I always kind of got to the point where I felt like in the opening statement, I'm just getting to know the jury. I really have to be pretty factual and pretty straightforward and not get emotional and all that, and just try to just be real straight with them. What would be your reaction to that?
I think that's I think that's a good approach, and I think you don't have to get emotional yourself. For example, on the plaintiff side, to discuss something that clearly triggers to the jury how emotional this case is and
Right.
what the plaintiffs have gone through just from an accurate description of what occurred in the case and the great loss that they suffered. Going back to the case I talked about with the missing baby.
Oh, yeah.
The facts of that case, just from opening statement on, just sort of spoke to what this mother must have gone through.
Sure.
And so I think let the facts of your case do the talking.
Yeah. And in the but as far as the opening, trying to be fairly straight, I always felt that when you got to the final argument and the jury had heard all the evidence and they had gotten to know you as a trial lawyer, if I was going to show some emotion, that's when you might show some in terms
Correct.
of making your final arguments.
I would agree with that. And by then, as you just said, the jury knew you. They knew what you'd done in the courtroom. They knew what damage you'd done to someone
Yep.
or some witness or something else. And for you to convey, I don't know if outrage is the right word. That's probably too strong, but to convey a sense of the injustice of what the other side is trying to do is fair and appropriate.
Yeah. Now, during the trial, we've talked about cross already, but another part of the case that's important, and sometimes people overlook it, is you got to have good direct exams of your own witnesses and people. And you've probably seen some great direct exams and some really poor direct exams. But
Right.
what do you see going on as a trial judge when people are really doing a nice and a really good job with their direct exam?
With a good direct exam, it flows well. There aren't a lot of objectionable questions that
Yep.
break it up. A common mistake is leading your client or leading your witness, and that enables the other side to chop up your examination. Um, Little things like knowing how to lay the foundation for exhibits you're trying to get in,
Yep.
so you can just flow through all the elements of the business records exception, boom, 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 move it in, admitted, then go on to the next.
Or
Uh,
have it stipulated to beforehand.
yeah, but I mean, I
Yep.
had cases where, a lawyer would say, "Is this a business record?" And the witness would say, "Yes." "Was it your business?" "Yes." Move it into evidence. Objection, incomplete foundation, sustained. And you'd almost want to tell the lawyer, what the other two missing elements are. But so I think proper preparation, moving smoothly through it, not over rehearsing it with your client because
Yep.
that can come across. But you're sort of the conductor at that point and can steer it where it needs to go. And then it's up to your client or your witness to do the rest.
Well, another factor that happens in direct and also happens in cross is I think the good trial lawyers, the really good trial lawyers will always be listening very carefully and actively. So you may have in your direct or you may have in the cross the witness saying something that maybe you need to explore a little bit and just go down that that area because it hasn't come up before, or it's important to the case. And you got to be flexible enough to do that in your direct or your cross.
Right. Yeah, I mean, one of the things you could see as a judge happening is the case you prepare and the case you try sometimes aren't the same thing.
Right.
And you could see it happening in the courtroom, by the reactions of the lawyers at their table. And I mean, I had one lawyer one time ask to come to sidebar, and they go, "Your Honor, this is completely different than what they testified to at their deposition." And so I said, "Well, thank you for that information. Anything further?" And yeah, so you're right. You've got to be able to follow the case where it goes, and or shy away from it if you see a trouble point coming up that you hadn't anticipated, and see if the
Or
other side.
like that example of the lawyer complaining that the witness was saying different things than they said in their depo. Well,
Yeah,
you have to be prepared for trial.
right,
And if you're properly prepared and you know the evidence backwards and forwards, you can deal with that witness if they're going off track, because you can impeach them, reduce whatever you got to do.
yeah. If you've not tried a lot of cases, um, you're not really familiar with how different things can be in the courtroom than what you expect.
Yeah.
And if you don't have a lot of courtroom time and a lot of understanding of how to attack that witness, it can be very frustrating.
Yeah. The
And
problem is I've kind of taken to describing it over the years as, you know, you can have a perfect practice in your office, but the only thing the jury ever hears is the reality of what happens in the courtroom. And, you know, you don't get to stop that.
right,
And it's all going to come out. And that's the only reality they'll ever see. And you got to deal with that.
right. Yeah, and when you're in the courtroom, you can't take a break in the middle of the depo and drag your client or witness out in the hallway and find out what's going on.
No.
And I would always tell lawyers, we take breaks at 10:30 and 3 o'clock, but I'm not going to interrupt a hot line of cross-examination
Right.
to take that break. What I'm going to say is now a good time, and that's your signal to tell me, 5 more minutes, Judge, or 10 more minutes. And because the whole point of the trial is, and you particularly see this from the judicial side, is to get to the truth. And my
Right.
view is cross is very important for that. And so I wanted to make sure that the truth outed in the courtroom.
Sure. Absolutely. Well, when you get to the final arguments, you've probably seen a lot of different styles and all of that. But, and I don't know if any will spring to mind, but you've probably seen some great arguments on the plaintiff's side, let's say in non-economic damages case, where they're explaining to a jury how they might figure out what fair compensation is. But you've also probably seen some great arguments on the defense side where they're also giving some examples. I mean, are there any examples you can think of that were some really pretty good analogies or arguments you heard on either side in the final argument that was helping the jury figure out how they're going to decide this case?
I think I think non-economic damages, from the plaintiff's standpoint, are relatively easy to argue. Of course, I haven't done it that much, so it's easy for me to say that. But in a case where you've got catastrophic injuries and the facts sort of speak for themselves.
Right.
Um, but I think it's much more difficult in smaller cases. And you can, in voir dire, you've covered with your jury the fact that you're going to be asking for this, and so they're aware it's coming. But some of the tools I've seen that are effective in that regard are using, for example, the life expectancy tables
Yeah,
and talking about this is a permanent condition. This person is going to be living X number of years. That's 365 days a year times, 15 years. That's whatever that turns out to be. I think it goes too far. I've seen lawyers then try to put a dollar value per hour, and then multiply that out. I think that's perhaps, shoving the horse's head in the water to get the horse to drink. But I think giving an explanation that gives the jury that this is permanent, how long it's going to last, and what the impact on the individual's life is going to be was probably one of the more effective ways to do it from the plaintiff's standpoint in the non-catastrophic concept. In
yeah,
the catastrophic realm, it's easier to ask for those larger amounts of money,
right,
and nobody really bats an eye at it. It's in the smaller case where you've got to build a basis to ask for that large amount of money. And I think tools like that are helpful.
right. How about with a catastrophic case? Have you seen some great arguments from the defense lawyers that might help a jury give damages that are significant, but maybe not as high as the plaintiff's asking for?
Yeah, I mean, I think from the defense side, in the catastrophic injury area, one emphasizing that your life care plan, for example, dealing with the economic damages and ensuring or letting the jury feel comfortable with the fact that this person is taken care of for life. And I think talking about the real life circumstances of the person and arguing for an amount of money that would provide them and provide some things that could assist them that were not purely economic damages, but improve their quality of life and the like, and try to tie it to that was effective. And then, I mean, you and I were trained by a lawyer who's recently deceased, who I won't mention, but he used to say to young defense lawyers, give the smallest number that you can say with a straight face and cut it in half. And so you do want to pitch low, I think, on the defense side, not too low that you lose credibility, but
Right.
I think you do have to suggest numbers on both sides, because I don't think a jury is really equipped, and you sort of want to have a jury that has an idea from each side as to what the upper and lower parameters are.
Yeah, I think that makes good sense. Although I think I've been on both the plaintiff side and the defense side, and on either side, I was always trying to think about, I don't want to suggest something that they're going to feel offended by.
Right.
I want to suggest something that they will think that makes sense. That's reasonable. I get that. They may not agree with it completely, but I don't want to make them think that I'm being crazy or too far one way or the other.
Right. Yeah, that's why I think either way, you've got to argue a factual basis for it, because juries,
Right.
they don't, they're not fluent in non-economic damages and what that is. And
Right.
part of the process is you educate them as to that. But you've got to provide a factual basis for it, in my view, on both sides.
Yeah. Well, Judge, this has been a great conversation. I knew it would be fun. It's been terrific. We're getting near the end of our time here, and I want to finish off with this one question I'd like to finish off with everybody, and that is, you may have received some great advice when you were a young lawyer being trained by these great lawyers you got to work with. You may have learned things over your career, but if you're going to give advice to somebody who's maybe hasn't tried any cases yet or only tried a few and they want to become a good trial lawyer, what piece of advice would you give them?
I think it's as I've mentioned it as you know, it's much harder now to get in front of a jury in the civil realm than it was when you and I started because of the expense. But
Right.
I think um, that you can approach your cases with the mindset that this case is going to go to trial. And what am I doing today on this case that's going to assist in this process? When I take a deposition, for example, and you get someone to make an admission, but it's in the midst of, a whole long narrative sequence where at trial you're going to have to read that whole answer when you impeach them to ask the follow-up question. So the light was red when they approached the intersection. Yes. Well, didn't you just say the light was red? And so to start thinking at the beginning of the fact that your case is going to trial and preparing it that way. And then second, look for opportunities like I've forgotten the name of it, but the small trials that you do in one day.
Expedited
And
jury trial.
yeah, the expedited trials, look for opportunities like that,
Yeah.
And even go so far as I know there's some lawyers who are able to volunteer with the city attorney's office for 3 months. I don't know if they still do that, where you could go in and try misdemeanors. That
I
would be
think that
valuable to pick 20 juries, in
I,
early in your
I
career.
think the DA still has a program like that too.
Yeah. So you have to look for those kinds of things. And then when you really get to the point where you're going to try a case, think strategically, don't be boring, and learn from whoever's around you that you can.
Well, all that is great advice. One simple example, like you gave on taking a depo, and we talked earlier about using video clips. You got to be thinking about, do I have a clear question and a clear answer, and they haven't gone off to other things because you don't want to read all that long thing. So you
Right.
got to keep asking the question until you get a clear question, clear answer.
Correct.
But if you get that on a video clip, that is gold.
It is. And there's so many times that lawyers have a nugget of gold buried in, a pile of tailings. And when you impeach them at trial, you got to read that whole pile of tailings.
Yeah.
And so a good trial lawyer will know to ask that follow-up question in the deposition.
Yeah. Well, listen, thank you very much. That's great advice. And thanks for sharing your wisdom with the listeners. It's a great discussion. I've really enjoyed it. And
Me
thanks for
too.
being a guest and keep doing your good work.
Well, thank you very much, Monty. It was a pleasure seeing you today.
Okay. Bye-bye.